Good morning.
Hi, Steve.
Hi. Hi, Kathy. I'm good.
Well, I think it is time for us to get started on session number 3 of our day-long CLE on military law topics at the National Lawyers Guild Convention. For those of you who are just joining us, just a few housekeeping things. Just a reminder, when you're not talking, to please mute yourself so we can help control background noise. We do have attendees in person as well as on Zoom. Just a reminder, the materials for the CLE, and I'll put the link in the chat real quick for today for our anyway, all the materials you can download at this link kind of go towards the bottom of the page. However, we have a few more things we'll be adding right after lunch, and so you may want to check after that to get the latest of everything. So that's the link for that. Also, I'll mention that just as a quick housekeeping thing, after this today is done, for those of you who've either watched live online or in person, I'll be sending out emails for the lawyer attendees so that we'll touch base about the CLE credit situation. Right now, we are approved for credit in Oklahoma. We're still pending for California, Texas, and Alabama. So we're hoping to hear from those soon. If you're from another state, what we'll do is we'll send you what's called a uniform application for CLE credit that you can submit to your state's bar. And I'll give you some more information on how to do that when we do that email. But also, we will also be sending out our course evaluation. And we'd really appreciate your comments on this. The evaluation is required, by the way, by the state bars. But also, we'd just love to get input. We hope to do more CLEs like this in the future. And so your input would be very helpful. So anyway, for this session today, it is for the third session. It's on the topic of defending resistors at courts martial. Your speakers for today are myself, and you already heard me introduce myself, so I won't repeat that. But for Steve, let me tell you a little bit about Steve. Steve Collier served as defense counsel for the first Iraq War resistor. He is a longtime staff attorney with the Tenderloin Housing Clinic in San Francisco and is an adjunct professor at, actually, we have the old version of the bio. So Steve, why don't you introduce yourself? I'm so sorry.
Well, that's all right, James. So yeah, my name is Steve Collier. I'm actually now the managing attorney of the Tenderloin Housing Clinic. I primarily do civil housing law. I've never done any criminal law except for the court martial, which is a type of criminal law in Stephen Funk's case. So I'm here, and I've been an adjunct professor at law, and I've done lots of trainings on military law with the MLTF.
So today, I think Steve and I were really wanting to speak a little bit from a very practical standpoint of, especially for lawyers considering taking their first court martial. And I will share just briefly, just for a moment, I'm going to hand it off to Steve, and then I'll come back in some at the end. I'll mention that it can be very intimidating stepping into court martial practice as a civilian lawyer, particularly if you're unfamiliar with it. I think there's a few things that give us some real advantages going into this compared to some other areas of new law. One being is that the military, for all of its problems, does a better job than the civilian world sometimes of having their procedures written down. In a lot of state and local courts, there's often a lot of unspoken rules about how things happen. A lot of things, if you're practicing in new court, can really catch you off guard. In the military, the good news, that's almost always can be found either in the judge's bench book, which we have access to, or in the manual for courts martial, which is the manual for courts martial, by the way. And I might show this on screen in a little bit too, just kind of helpful to see it. But it is this massive volume that contains the UCMJ, the Uniform Code of Military Justice, federal statutes that serve as the highest law, you might say, under the U.S. Constitution for the military, but also includes interpretative documents that explain the UCMJ, that flesh out what the UCMJ says. It also contains a great deal of the procedure used in military courts martial as well as in some other procedures. And so I really appreciate the fact you have that actually available. And again, I wish that such a thing existed in more civilian contexts. Another advantage, and it's also a challenge too, is the fact that in most cases, as a civilian defense attorney, you will likely be working with military co-counsel, that is defense JAG, the public defenders of the military. And I'll touch on based on that a little bit later on, but that is an advantage and a bit of a safety net. However, you have to go into it not being too reliant on that safety net for reasons we'll talk about later. So I'm going to go ahead and hand it off to Steve to share some of his experiences, and then we'll go from there. So, Steve.
Well, thank you, James. I assume I can tell from on Zoom, I know everyone on Zoom pretty much. And what I don't know, as far as people in the audience, but my general question is, has anyone ever done a court martial? Um, and I am assuming maybe, James, you can tell me if there's people in the audience who have.
I think we have a few people who have either
Okay.
online or in person, but most of the folks I think would be new to actually doing courts martial.
Okay. So I'll sort of do it, which is what I'm used to doing, is telling people how to do your first court martial. Um, the thing that's important to realize, and James touched on this, is that civilian defense counsel um, can can really do, if you're a good attorney, can do a really good job. I mean, it's really laid out for you in the manual for courts martial, in the judge's bench book, especially if you have some familiarity with federal rules, the rules of procedure, and the rules of evidence are very similar. Um, Trial skills are universal. So you're basically doing a criminal defense trial. So you want to use your skills of persuasive fact analysis, interviewing and examination skills, and persuasive argument. The hard thing is to get past the jargon and the acronyms. There's a lot of jargon, and there's more acronyms than you could imagine in the military. And sort of, they operate it knowing that stuff. So you're sort of always feeling like you're catching up because they're using acronyms that you've never heard of or that you're not familiar with. Um, but the court itself in my experience, was surprisingly respectful, courteous, and even helpful environment. Even though I had a military judge who was considered a very tough sentencer, he liked my defense motions and granted them in many cases. He was kind of like he was really interested in unlawful command influence. He had a reputation of liking to thumb his nose at the command if he felt there was unlawful command influence, and there was in my case. So I used, the area defense counsel that was assigned to the case was helpful in that regard in pointing out kind of aspects of this judge that I wouldn't have known about had he not informed me. So with in any court martial, the accused has a right to a civilian defense counsel at their own expense, and also a right to an appointed defense counsel from the military. And you can have both. You can choose both. You can either have just your civilian attorney represent you, just have your area defense counsel represent you, or you could have both. And we chose to have both. So Stephen Funk was one of the first conscientious objectors, people to announce his opposition to the Iraq War. He was in the Marine Reserves. The Marine Reserves are based in New Orleans. That's where the central command for the Marine, so to speak, for the Marine Reserves is. He had enlisted, like many of our clients. He was very young, very naive, sort of enlisted for all the reasons you normally see. Life is difficult, wanting to start out on a new path. After 9/11, having a feeling of, patriotism to defend the country, but really did not understand at all what he was facing when he enlisted, and through the boot camp process really realized he didn't want to be a soldier. He was painfully shy, um, difficult childhood. So really, it was a huge deal for him to announce himself as a conscientious objector and a resistor. And we had a big media event at his base in the Bay Area. The His case drew about 47 media outlets throughout the world to cover it. he did a press conference out of uniform and switched into uniform in my back of my car and turned himself in. We videoed the turning himself in. The um, the officer who accepted him, who was the commander at his base, made very damaging admissions that were on videotape that we used in the court-martial trial. So I guess the lesson is that treat everything with a view towards trial and try to create evidence where you may not have it if you are just relying on the normal courtroom procedures. Again, I'm a big believer in media. I'm a big believer in bringing pressure points to bear on the military, and in all my civil litigation, I do that too. To bring pressure to bear on the government, and it was very helpful in Stephen's case. So we had a teamed approach. We had a defense team. That was the attorney was me, that was the lead attorney, but I did work with area defense counsel. I also had a very experienced military lawyer, Luke Hyken, from the Vietnam era, and who was continuing to do military law in the Bay Area as sort of like my senior counsel, the one who was advising me, especially on the law and procedure. He was very helpful in with the command influence motion, the unlawful command influence motion, which I'll talk a little bit about in a minute. I had a law student who was researching for me, doing a lot of good research. I had a local attorney in New Orleans because I didn't, have really much access to any office or anything if I went to New Orleans, but I had a local guild attorney, Mary Howell, who helped sort of set me up there, because I was there for the court martial itself was about a day, but the judge was delayed, and so we got, I arrived, and then there was no trial for a few days because the judge was delayed. So I was preparing, out of her office. We had media. We had a local group that was helping us with fundraising to cover the costs of litigation. We had a videographer. We had a priest who helped testify, who knew Stephen, who testified at the trial. And we had former COs, former members of the services who were also offering support. Let's see. So as James mentioned, the manual for court martial is it's like a cookbook practically of how to do a court martial. There's actual scripts that the trial attorneys use, that's the prosecution uses. They're in the appendix. There are forms, which are in the appendix number 5 for forms that are used in the court martial, so you don't have to reinvent the wheel. You have broad discovery rights. Trial counsel, like in the criminal context, must affirmatively produce evidence, including exculpatory evidence. They have to produce witnesses. You can make a motion to have a witness, flown in if they're material. Of course, the military may oppose that. You have to show their materiality. But you do have those powerful sort of subpoena-like powers.
I'll mention one very practical thing on the defense side of things, and that is, absent a plea bargain situation where you may have to waive this right for other reasons, the military act, you can actually, in producing military witnesses, the military actually has an obligation to bring the witnesses to the trial. Mm-hmm. Which means you could call someone as a witness who might literally be on the other side of the world, and the military in most cases will have to accommodate that. And so that is what it often practically is, it's a tool in plea bargaining. It's to say, look, if we can't get X, Y, or Z, we're going to go to trial. And if we go to trial, we're calling this witness and this witness and this witness. And it can often change the leverage of the situation, because the military knows then they're going to be on the hook for getting this person pulled out of their regular assignment, maybe taken off from a deployment and brought to this post for a trial. And so there are some things there that can be very useful. That said, often the military, in certain contexts, that sometimes telephonic testimony is allowed in a court martial. Whether you agree to that or not, it's a whole other question. Often from the defense side, one of my challenges is my clients in a plea bargain situation, we don't get the government to pay for our witness travel. And so often one of the conditions might be, if we are agreeing to that term that the government doesn't pay for witnesses, we also get the government to agree they will not object to telephonic testimony in certain cases. So there's a lot of these issues can be negotiated, and really nothing is set in stone. A lot of it is a matter of negotiating.
And a lot of those negotiations happen in what's called pretrial conferences, or an 802 is the reference in the UCMJ, I think, or the rules of
Yes.
procedure.
One thing that's changed a little bit, though, in the
Mhm.
last 15 years or so is that so much now is happening by email prior to those
Okay.
802 sessions. And so, and I actually greatly prefer that to the civilian world, where often we can have some initial phone calls, but not much really happens until you're in chambers talking to opposing counsel. In the military, many things can be resolved via email, and I like it as a paper trail. One factor also to bear in mind for negotiating is that the prosecutors in the military, they are what's some are referred to as trial counsel, some is referred to as SJAs, the staff judge advocates, but they are these are lawyers who wear two hats. One, of course, is they're the prosecuting attorney. Secondly, is they are the command's legal advisor. And that's a complicated relationship. It also is complicated because their ability to negotiate is limited by what their boss says, their commander, who also has a great deal of control over this whole process. Despite of course, the rules and unlawful command influence, there's still tons of ways that commander still can shape the process, and so that often makes it complicated.
So that segues well into unlawful command influence. So we did an unlawful command influence motion. The command in this particular case, it sets up the court martial. They appoint the panel, the jury panel, and the commander in our case actually appointed himself onto the jury. Um, and actually sent out a memo because there was all this media attention to the trial saying, well, there's going to be this trial, and we just want you to know that, there are those sort of loyal Marines who serve, and then there are those, who resist, or they didn't use that word, and those are being all brought to New Orleans to be to have their cases determined. So that memo was very important because it set up the basis, and something in writing that we could say the command was doing unlawful command influence. And so unlawful command influence is most often exerted on members in any of the following populations. So that's the subordinate commander. I'm reading from the criminal bench book now, the military bench book. Potential panel members and potential witnesses. So the panel was composed of people from the base in New Orleans. So it definitely, and it can be exerted by commanders as well as those acting within the mantle of command. And it can be intentional or inadvertent. And you just need to have some evidence. The threshold is low. That's actually written in the bench book. It says the threshold to prove unlawful command influence is low. But the defense still has to prove it, and then the burden shifts to the government to show that the proceeding essentially won't be influenced by this. The judge basically, in our case, removed the command from they could dismiss the whole proceeding, but he didn't do that. What he did is he removed the command and appointed and required that a different command from a different base be the convening authority for the court martial. Now, did that actually make a difference? Well, it did make a difference as far as the jury panel. We did not have that commander on the jury panel. Um, and so what ended up happening in our case is because um, he was charged with desertion as well as missing movement, because desertion is a specific intent crime, and because he never had the intention to desert, because he always assumed that as a conscientious objector, he would not have to serve. The Marines had their policies on conscientious objector were that conscientious objectors would never be deployed into the field if they submitted their application prior to their call-up. And he did that, and therefore they would be processed stateside and never be sent to the battlefield if they had a pending conscientious objector application. So because that Stephen understood that, because I counseled him on that, we argued that he never had the specific intention to desert, because he always assumed he would never be deployed in battle. And the judge was good on it. He gave us the instruction. The jury asked for a readback during uh, their deliberations. The judge read it back, emphasizing exactly what we wanted him to emphasize, and they acquitted him on desertion. They did, the missing movement, was a lesser included offense, and we did not really have much of a defense on that. So he was convicted of missing movement. But he beat the desertion charge, which was major, and was a great result for him.
And what was the sentencing case like in his case? How did that play out?
Right. So one thing I'll have to say is that I was sort of expecting, like in criminal law, you come back the next day for sentencing and have time to prepare. But in this case, it was like 8 p.m. And it's the military, that they don't stop, right? So they just kept on going at 8 p.m. and said, okay, we're going to do sentencing now. And I was like, holy shit, you know what? But basically, if I recall correctly, the jury I don't really have a good memory of it, but I think the jury sentences
Mhm.
in the courts martial, and they, you know, we pretty much made the same arguments for sentencing that we were for liability, for liability, which is that, he didn't have this intention. He was just a conscientious objector. He shouldn't be punished because he's sort of was never a good Marine to begin with. He's never set up to be a good Marine. He shouldn't be punished for just being who he is. But he ended up getting a bad paper discharge. I think his sentence was made maybe for less than a year, or maybe a year
Mhm.
and a half. I forget. It wasn't the full sentencing that he could have gotten for missing movement. And he served it, and got out with whatever the good time you get for serving your time. Um,
Yeah,
and
one bit of good news I will mention on sentencing is that if you look at the possibilities of what someone be given that's listed in the manual for courts martial, those kinds of sentences are not given out in the modern era, for at
no,
least for absence related offenses and things like that. I think the longest possible sentence I've heard of in the last 20 years has been about 2 years. I think that's happened once. I think it's been a few times around 18 months. Most often it's a year or less. And so I think that's one thing we can reassure our clients about. Now, that said, I also tell my clients theoretically it's still on the book for much longer. In practice, no. Now, I will say one complicating factor is these in the past, how things were defined was convictions in a general court martial that resulted in a dishonorable discharge or a sentence of more than a year were treated as felonies in the civilian side. Anything other was counted as misdemeanors. That appears to be changing, and it's not completely clear on what basis. And the reason I have a client who was convicted who got a BCD, bad conduct discharge, got a relatively low sentence, but recently found out when they tried to buy a gun that the military had reported them as having a felony conviction. So there may be some pushback on that. I could see that being an issue of litigation. I will mention for many of us who are from more of a leftist perspective, the issue of whether you can buy a gun or not, I think for a lot of us is like, well, why would I want to? But I do want to mention for many of our clients, particularly who live in other parts of the country, different dynamics and whatnot, that's a very important thing for some of them. And so I have changed my what I tell my clients about consequences of a military conviction. It appears now that what the military is reporting to the federal background checks for firearms purchases is anyone who's convicted of a crime that could be punished by a year or more now is they're reporting that as being a conviction of a felony. Again, I think eventually someone needs to litigate that issue. I'm hoping one of the gun people can do it so that I don't have to make that argument. But I think someone should, because I do think it's really unfair that someone accepted a deal believing that they would not have a felony conviction and later to find out that the goalposts are being moved. It's a very frustrating thing. I'll mention too, I want to talk just a little more on sentencings. I think this might be a good segue point for that.
Sure.
In the military, a couple things about sentencing is that in absence related offenses, often what we're really dealing with as far as the guilt innocence side of it is AWOL, absence without leave, is a very easy thing for the government to prove. They have to prove that your client was not where they were supposed to be, and they had no legal reason to be someplace else, and that there is no legal defense to those crimes. They have those satisfied, they have an AWOL conviction. Very little on the defense side that we can do to push back on just AWOL given that fact pattern. However, the other potential things like missing movement, desertion, those have intent elements attached to it. Well, particularly for desertion, it's going to be either the intent to shirk hazardous duty or the intent to remain away forever. If you can, and so those intent elements are really important to prove. And so very often the negotiating process is on what will the charge actually be. But assuming that the fact pattern are such that your client says, that the decision is made that no, we really unlikely to get a not guilty. At that point, negotiating becomes even more critical because the issue you have is leverage. From the defense side of things, what we have as leverage is that we can make the government pay for expensive witnesses to be brought in. We can tie up a jury panel of 6 to 12 officers or half officer, half enlisted if it's a civilian defendant. Those are our main leverage points is expense to the government. And so in the negotiating process, one of the things is maybe trying to get that desertion charge down to AWOL. But another thing is trying to get the sentence cap as low as possible. Because unlike in the civilian world, where normally a plea bargain is reached between both sides, the judge approves or disapproves, so there's not a lot of room for anything else. In the military, what happens in a plea situation is a pretrial agreement is executed where that both sides are agreeing what is being pled to. A stipulation of facts is included, which are uncontested facts. Both sides are agreeing. And then there's the quantum. This is a document that lists maximum punishment caps. And so those might include not giving a dishonorable discharge. It might include a cap on jail time, saying no more than 3 months of confinement can be given. It might say other conditions. But the idea is that this is negotiated between defense counsel and the prosecution counsel. The important thing is that who you're actually negotiating with is actually, though, the convening authority. That is the level of the chain of command that has sprung this court martial into effect. So they have to approve any kind of pretrial agreement. But once that is approved, then instead of having a trial on the merits, you instead first have what's called a providence inquiry, which is where the defendant has to prove that they are guilty of what they're pleading guilty to, which is a little bit different than the civilian world. In the military, there's a great deal for good reasons to make sure that someone is not being coerced into taking a deal they don't want to take. And so the average providence inquiry, even for a very basic AWOL case, will probably be at least an hour, maybe 2 or 3 hours. The judge will ask in detail questions to ensure sanity, to ensure not having been voluntarily intoxicated, there wasn't any legal defenses. So providence will take a good bit of time. After that is settled, the judge says, yes, I pronounce you guilty. At that point, you move into sentencing. Now, bear in mind, in the hypothetical we're talking about, we have a pretrial agreement. We have a deal in place. And so then when we argue in front of the judge, both sides will argue what the sentence should be. The judge knows there is a pretrial agreement, knows what the stipulation of facts is, does not know what the quantum sheet is, what the maximum cap on the sentence is. So then, if it's judge alone, the judge, well, actually, in a plea bargain situation, it would always be judge alone. So the judge would then, here's the sentencing case. The prosecution basically explaining how many different ways your client is a scumbag and all of the ways that they have brought discredit on the service. And then the defense, we get to argue mitigation, extenuation. We get to argue everything that shows why this person should be punished less. So then the judge, then after hearing both sides, hearing closing arguments, the judge goes back to chambers and then comes back and says what he or she thinks the sentence should be. And then finally they look at the quantum, and whichever is lower is what sticks. And so I tell my clients is we get a second bite at the apple. Whatever we first negotiate to get that pretrial agreement as strong as possible. Then we go in front of the judge to make the case. So when you go in front of the judge for making the case, the important thing is we can be very creative. Of course, witness testimony can be very useful. I often will call parents of my clients to the stand as witnesses. They're very compelling people. Often there's emotion shown, which can be helpful in some of these cases to humanize the defendant. Also, prosecutors have learned don't cross-examine mothers harshly, which is, thank goodness that's the case. But I often will coach the mother, in particular of a client, to say some of the more important things, because I know the prosecution will be very unlikely to push back on cross-examination with a mother. In fact, one of the times the opposing counsel did do that, the judge later, we had a bridging the gap session after the trial where all the attorneys went back at the judge and the judge critiques us in our performance. The judge was not impressed with the prosecutor that cross-examined the mother, was not impressed at all, made that very clear. That was a bad move. Don't do it again. So from a defense standpoint, it means mothers are good to have as to testify. Another thing that we are allowed to do in a military court-martial is your client can give, they can give sworn statement, but they do not want to give sworn statement, and I'll tell you why. Sworn statement means they open the door to being cross-examined. We don't want to do that. So instead, they want to do the other option, which is an unsworn statement. An unsworn statement, according to rules, the judge is supposed to take into account that this is an unsworn statement, should bear it less weight. In practice, what it means is your client can say almost anything they want and not be cross-examined afterwards. And what they say can be verbal, them giving a verbal statement. It could be question and answer. I've had clients who were extremely nervous, who really had a hard time with this. And so I did it question and answer format. I had one client who was so anxious and tearful, he could not say a statement. So I read it on his behalf. And in that case, what I did was what I do too, if it's a pre-written statement, I will give a written copy to the judge to take back to the chambers, but we'll also ideally have the client read it, or if not, I will read it. But it's our chance to get things in front of the judge. We also, as part of the unsworn statement, as attachments to that, we will include what the military calls your good soldier book. That's certificates, awards, letters of recommendation, all that stuff you keep to build up your career in the military. You present that as part of your unsworn statement too. And so giving the judge lots to think about when they go back into chambers. But this is a chance for a lot of creativity, but it's also for many resistance cases, this is also their chance to speak to the government and to tell them exactly why they did what they did. And I've had clients who said, I know I'll get more in trouble if I say it this way, but I want to say it this way. And my job as a lawyer is not to tell them what to do, but to give them the information they need to make their own decisions. And so I've had clients who said very scathing things about the military and why that they're doing what they're doing in their unsworn statements. And as long as they knew it, that's their call to make. But it is a really unique opportunity for sometimes defendants who have been told over and over again, you can't speak. You don't have the right to speak. Now, in a military court-martial, they are getting to tell the judge and often their commander exactly what they want to say. And so that can be a really powerful thing.
So just to follow up on what James said, just to be clear, in case you don't know this, with the pretrial agreement, whatever you and trial counsel have agreed to as the maximum sentence, that's it. Even if the judge was to come back with a higher sentence, the pretrial agreement limits it to whatever that agreement says. So, if you have a resistor you're worried about pissing off the judge, you could tell them, well, the pretrial agreement caps it at this, that's the maximum sentence you're going to get.
Another factor on that as well, another cap is the venue, the kind of court martial someone is in. And I
Mhm.
had a case of someone who was on the fence about whether they would plead. He actually did not want to plead guilty. The charge was just AWOL, but he absolutely did not want to plead guilty. He wanted to have his day in court. In the end, we thankfully, the government came back and said we're going to try him in a special court martial. Now that's important because being tried in a special court martial caps the sentence, at least in the rule may have changed a little bit since then, but at that time the sentence cap was 12 months of confinement, no worse than a BCD, bad conduct discharge. And so for that client, he knew going into it that he was expecting a cap of a year in prison, and he made the decision of, okay, I expect that. I'm ready for that, but I want to have my day in court. So his decision was to plead not guilty. We made a very creative argument in his case, did not prevail, by the way. We argued that the Miranda decision, which said that you should be informed of your right to be silent in the military, we asked the court to adopt a similar position, requiring that people who are about to be deployed should be told they have the right to file for CO status. We knew that wasn't going to go anywhere, but we wanted to make that argument, and so we did. The reason we did, though, was because we were in a special court martial. I would have strongly urged my client not to take this position if he was in a general court martial, where the sentence could be much higher. But given that assurance, he was ready to do it. And guess what? He got 12 months in jail. We could not get a better deal. In that case, because of not guilty plea, it was in front of a jury. But for my client, it was powerful and meaningful for him to tell six Army officers exactly why he did what he did, and why that they should be telling all of their troops that they should look at conscientious objection before deployment. It was a powerful thing, but it was the client's decision. He was empowered with the information he needed, and then he acted.
Well, I don't have anything more to add, James.
Okay. Well, I think for our last few minutes, I think we might talk about a few other issues, and then we'll have some time for questions along the way. So if anyone has questions, again, we'll put them in the chat. One thing Samantha had asked, what safeguards are in place, if any, on the commander's jury selection? Any preemptory challenges? I'd have to look at the manual for courts martial for sure on this point. Usually you have a certain number of challenges right off the bat. But for the most part, the commander has pretty unlimited discretion who they pick. And unfortunately, not a ton of case law on that point. I would say one of the most challenging aspects of military law is that there's not much case law to speak of. There's a few reasons for that. One of the problems is that the military appellate process is so slow, and the sentences tend to be proportionally relatively short for these kind of cases, that often, if someone does appeal a conviction, they're out of jail by the time the appeal is heard. And so because of that, it often means that appeals actually aren't made. Things that should be appealed don't get appealed. And because they're not appealed, case law doesn't get adjusted. And so I would argue that I would love to see more appeals be made so we could flesh out some of these issues. But unfortunately, there's some of these issues that have been fleshed out more in the civilian world that have not been in the military context.
Yeah, so
Um,
other than peremptory challenges, also if you're an enlisted member, 1/3 of the jury has to be people that are enlisted, although they can't be of below rank.
yeah.
Um,
Now, one of the debates for enlisted defendants is, should they ask for enlisted people on the panel?
mhm,
One of the conventional wisdom says is that well, one is, who will the convening authority pick as the enlisted members of the panel? It will not be your client's peers, people of the same rank. It will be people ranked much higher. So you're talking E7s, E8s, and again, military conventional wisdom is those are all the hard asses. And
mhm.
so the conventional wisdom is ask for officers rather than part enlisted. I'm not so sure about that. The one case that I had in this situation, we went for all officers following conventional wisdom. I'm a little more dubious of that now, so I'm not sure. That would be something I would probably especially lean on my military co-counsel to ask what kinds of people does this convening authority tend to pick, and to get a feel for should we ask for a mix of enlisted or officers. But that's where having that insider information, having your military co-counsel can be really helpful.
Yeah, very
Um,
helpful. And for someone who's not familiar with all the jargon, he can read the medals, he knows the stuff on their shoulders, what that means. He said that guy's recon, you don't want him. So reconnaissance, someone who's in a reconnaissance unit, they're going behind enemy lines. They're not going to be fearful and understand a CO's point of view. So
yes.
that was very helpful to have Area Defense
Mhm.
Council.
So a few practical things for court. One is I'm glad you mentioned about the what's on their shoulder. Uh,
Mhm.
because I practice in all of the branches, it's hard for me to keep track of all the ranks. And so when I have on court martial day, I actually print out a sheet that has all of the insignia of the ranks of people I might encounter, just so I don't mess it up. And I've learned that's the one that you don't want to mess up someone's rank. You want to dress them properly, so I don't make a mistake. I have that. That's one of my cheat sheets I have on trial day, of having the ranks lined up. Can be very helpful. The other things I always recommend is, unless you have a crazy judge, and there are a few like this who bid all computers from the courtroom. I argued successfully against this, but he made it clear, don't expect this to happen again. If you come back to my court, no computers in the courtroom. Most judges are not crazy like that. And so because of that, my recommendation is to have the MCM on your computer, Manual for Courts Martial, and have the bench book. Having those queued up, ready to go on the computer can be very helpful. If I ever happen to be in that judge's courtroom again, unfortunately, that means I'd have to print out the whole MCM and the bench book, which is a big pain in the butt. You might check with your defense co-counsel to see if they have it printed out. But having those ready to go is very, very helpful. The bench book in particular gives the script for what happens in a plea and sentencing hearing, for instance, and being able to track that can be very useful. Also, some of the issues on jury instructions and whatnot, at least the starting points for that are in the bench book as well. In our last few minutes here, I was going to talk a little bit about some related issues, particularly as far as the relationships we might have with the players in this process. One of them is military co-counsel. A few things to know about military defense JAG. One is that in most cases, these are very motivated, thoughtful people. I've had a few bad experiences, but I would say at this point, 90% of the time, my experiences with military co-counsel are very positive. In fact, some of them really enjoy working with a civilian lawyer because we do things that they don't get trained to do. Um, and so it can be a very positive relationship. What I will say is that you, as the civilian lawyer, you sit first chair, which means you can override your co-counsel. You get to make the final call. But that said, there's no reason to rub their noses in it. And so I kind of go out of my way to make sure the co-counsel feels respected. And I try to acknowledge the part that they play in the case along the way, and tell them that verbally, because I think it makes a difference. I also try to have some thoughtful consideration of them about division of labor. And so, for instance, a typical, let's say I have an AWOL case and let's say that we are in a plea and sentencing situation, not a trial on the merits, but a plea and sentencing case. In that case, a typical division of labor might be, I might ask the defense JAG to focus on providence, that first part of the hearing, which is very formulaic, can be a little bit tedious. Often there'll be just a few issues at stake. I may hand that off to them completely. I like that for a lot of reasons. One is that providence inquiries can be a little bit technical, and they know that judge. They know what things that judge may really want to hammer on. And so having them do that part is very useful. Sentencing, most of them, I want to be the main person there. And the reason is that sentencing is all about humanizing my client. I know my client better than they will, guarantee of that. And so, because of that, I want to be the one telling my client's story. I want to be the one talking to our witnesses. Now, on the other hand, cross examination is a little bit tricky. Often, let's say, the prosecution brings forth witnesses for the sentencing case. often I will ask my co-counsel to cross-examine military witnesses. And the reason for that is I don't want to miss anything. And there might be some specific piece of military culture that this whole thing could ride on. I don't want to miss that. But sometimes what I'll do instead is if I do the cross-examination, I will ask the questions, and then I'll ask you, say, Your Honor, may I consult with my co-counsel? I'll then tell my co-counsel, like, hey, is any other questions I should ask? And again, sometimes they tell me something really good. They picked up on something that I just, as a civilian, I'm not going to catch. They do. And so then I'll go back and ask more questions. That's completely fine. I've never had a judge give me a problem with asking like in a cross-examination situation, can I consult with co-counsel? It needs to be snappy. 20 seconds is fine. Don't push it. But that's usually very doable. But anyway, having thoughtfulness about the division of labor, I always do the closing arguments, and that's where and closing arguments is just like in the civilian world, where that it is ideally a bit of it's somewhat scripted, somewhat not. You need to be ready, of course, to be responsive to what things that the government may say in their closing arguments. But the biggie is making a connection with the decision maker, whether it's the judge or a jury panel. That's your chance. And take as long as you need. I've seen people rush closing arguments. That's a mistake. If you need to take a pause, that's fine. I will tell you from another kind of cool thing in the military is very often judges will have what's called a bridging the gap session. Well, they'll invite both sides' attorneys afterwards for a critique in front of the judge. It's private. No one else is there except the lawyers and the judge. Most of the time, I get invited to those, not always. Some judges don't want civilian lawyers back there. Most of them, they'll invite me. And what I will tell you from what I've heard from those judges is they are not impressed with completely pre-written closing arguments. I've heard them tell prosecutors, like, you need to listen to Mr. Branum here. He was fluid. He was engaging. You were not, which was kind of awkward to have him say that. But I will say, having it too stiff, that does not a lot of judges don't like that. At the same time, the judges do want to hear that they're really looking for you to zero in on the key issues and make them come alive for them. And humanizing your client is really important. Also, I'll mention that as far as opposing counsel, they will be, in my opinion, have shown themselves overall to be much more polite and easy to work with than civilian prosecutors, to be honest. I don't always like what they say, but these are you can expect to be treated respectfully, to not have problems. And so I try to do the same in return, and usually it gets very good results. One other thing about courthouse personnel on the defense side is that the defense JAG, they have paralegals, and those paralegals are really good at one very important thing in particular, and that is that good soldier book, which is almost always included as part of the defense argument. And so very early on, I ask the paralegals to take charge of that. And I do that very intentionally because they have all the time in the world. They can make it look pretty. But I'll still look at it. Sometimes I'll give them inputs like, oh no, we need more of this in. But for the most part, they're really good at that piece of it. Okay, so the last thing I want to talk about, and Steve, you touched on this a little bit earlier, the role of media in courts martial. This is tricky because I think the landscape has changed in the last 10, 15 years. It used to be a lot easier to get media attention than it is now. I'm finding it these days much more difficult, even with very deserving cases, to get media to be interested. I will say the best media I've received from courts martials themselves have been reaching out to local reporters in that military community. Getting them to write a story on a case can be a game changer because they usually tend to be fairly informed on military issues. They go into details you wouldn't get otherwise. But there are some military communities where that's very difficult, where the press is pretty hostile towards anything that's not just what the military's position is. It can be very tricky. I would say these days, it's really a calculated choice for the client, and really also one of the bigger factors is it's what the client's goals are. If their goal is simply to get the best sentence possible, it may or may not be advantageous to go to the press. It depends on the circumstances. On the other hand, if they have other things at stake, they have a mission, they have a message they want to share. They're wanting to use their resistance to empower other things. dealing with the press can be very helpful. And that's why cultivating those good relationships, finding sympathetic reporters, working with them can be very helpful. I think one thing on Funk's case, where was he based out of originally?
It was in like Santa Clara, California, was his reserve base.
Well, and that was in the Bay Area, right?
Yeah, but the court martial was in New Orleans.
Okay. But I know like in that case, one of the things you were able to do is a lot of the media attention was from reporters in the Bay Area that you did
Yes.
get right. That can make a big difference. And so sometimes if you can't get local press where the trial takes place to be interested in the case, you may have to go further afield. Another strategy that can work really well if you're lucky is to find a freelancer or someone like that who does longer feature length type of stuff and try to get them involved in the case at an early point of reporting on it, even
Mhm.
as you're getting ready for trial. I've had some good experiences with that, of inviting reporters at various points to follow the case through, and that can be a way of getting good attention, media attention when you need it. So, well, we are officially out of time for this session. We'll leave the chat on for just a moment though, and we'll keep this open the next few minutes if anyone has any follow-up questions or anything. But also, I do need to mention our second code for this hour, which we didn't give early. Let's see. Actually, our codes, the codes for this hour are U and S. U is in uniform, S is in Sierra. So again, the codes for session 3 are US, uniform Sierra. Just a reminder though, for this afternoon, we'll be back. The CLE will start again at 1 p.m. Central. And we have 3 more hours coming, some really good programming. Just a reminder that the Zoom link changes for the second block of programming. And that's just because Zoom has a limit on how many hours you can have. So just keep the recording length shorter too. So that will start up at 1 p.m. Central. But if anyone has any last questions before we break for lunch, feel free to unmute yourself.
Thanks everyone for being here. Sorry for that.
I want to perceive if he has any thoughts of how he wishes Stephen Funk's case might have gone differently.
We have a question from someone in the audience. So you'd asked if you had, say that again. So someone in the audience here asked if for Steve Collier, if in Stephen Funk's case, is there anything that you wished was done differently or handled differently in that case?
Well, I think I wish I was better prepared for arguing sentencing. I was kind of worn out and expected a break and to come back the next day. Um, but no, as far as the team was really supportive. Um, it was it worked out really well. I was very pleased with it. The other thing I wasn't, I didn't realize this until I did it, which is that pretty much all the witnesses were enlisted people, and the trial counsel, the prosecutor, is a major, right? So, you know, if he asked someone a question, he got yes, sir, yes, sir, yes, sir. It wasn't like the enlisted person was going to say something that he didn't want to hear. So for cross-examination, you have to keep that in mind that like, okay, you need to sort of understand that and try to bring out the fact that he's basically saying yes to a superior officer because that's what he's trained to do, and not
Absolutely.
necessarily giving you, the full story. So that's
Mhm.
a challenge that I didn't realize that maybe, with more thought, I could have sort of gotten better information from their witnesses.
Sure. I'll mention too on the issue of time, military courts martial, some judges are very reasonable, some are not on scheduling. But part of I see as the civilian defense lawyer, it's our job sometimes to be a little bit pushy about things like that. One of the things I've seen is that very often, particularly for a one-day plea and sentencing hearing, where that providence inquiry and then what I will really try very hard to push for is after the providence inquiry is done, I strongly and if they say no, I will put on the record pretty strongly that this should have happened. But I asked for a break between the providence inquiry and the sentencing, so my client can have some time to decompress. The sentencing, the providence inquiry is difficult because they are effectively saying, I did X, Y, and Z, and the judge questions them very relentlessly on that process. And so after it, just to me, shifting gears now into, okay, first I had to prove I'm guilty. Now I have to shift gears and show why I shouldn't be punished so hard. That can be a really abrupt change. And so having a break is ideal. In fact, a lot of judges will, for a plea and sentencing hearing, what begins in the morning, my preference, and many judges love this idea, is we take a lunch break. Often, like right after providence inquiry, let's say we're done at 11 a.m., then usually I say, Your Honor, can we either have a short break for my client to debrief before we move on, or would this be a good time for lunch break? And very often the judge will say, yes, this is a great time for lunch break. So having a game plan for that. I'll mention as a lawyer, one thing I do is I've learned after trying various different things, I always pack a lunch on court days. I don't try going somewhere. And usually I need the mental space. And so often defense JAG will have an office on base that you can use. And so often I'll coordinate with the defense attorney and the co-counsel, and I'll go to their office. I'll be set up there getting ready for the sentencing case. I'll eat my lunch I brought, and it just goes a lot smoother doing that. Usually, by the way, on court day, from that kind of situation, your client will usually, sometimes what they'll do is they'll escorts, these members of the unit that escort them everywhere. Sometimes they want to take them to the PX to get food. A lot of times I'll encourage them to say, look, could one of the escorts go get my client some food, and my client can stay with me during the lunch break? And we do that sometimes, but it's silly little things like that can make a big difference. Yeah. Any other questions? Okay, well, we will see y'all after lunch, 1 p.m. Central, and thank you, everyone.
Well, thank you.
Thank you guys so much.